Yes, I would like to draw attention to the perspective of the right to a fair trial when we're talking about the freedom of expression and association of judges. Because it also has already been mentioned, this freedom of expression and association of judges is of course limited. It's certainly not an absolute right. And the right to a fair trial produces one of those limits to the rights of the judge to express himself. And this perspective of Article 6 is not only of an interesting from a theoretical point of view, but also from a practical point of view, because it forms, at least in the Netherlands, Article 6 case law forms the basis of recusal proceedings. So it's of a practical value for everyday adjudication as well, this point of view. And it's already been said that the judge is nowadays drawn in different directions. It has already been mentioned that the judge has a moral duty under certain circumstances to speak out, more specifically to speak out in defense of the rule of law. On the other hand, we also have opposing duties, the duty to be independent and impartial. And these duties, they may clash. And for a proper understanding where this moment of clashing lies, some knowledge on the perspective of Article 6, I think is very useful. In the Netherlands, we have had, for instance, a case of a Dutch judge who was also the head or the chairwoman of an association of judges, who stood up for judges, for instance, in Poland and Hungary, who had difficulty with regards to the rule of law. And she had been very, very in the media about the situation in Poland. She, for instance, had said something in terms of, the Muzzle Act, the Polish Muzzle Act, a number of those remarks in the media. And she was subsequently confronted with a challenge, a recusal request of the public, of the office of the public prosecution, because she was also at the same time handling Polish extradition cases. And the public prosecution office was of the opinion that she had jeopardized her impartiality with these strong statements in the media. And the courthouse of Amsterdam, who ruled on procedure, or on this recusal procedure, indeed agreed with the public prosecution office that this was, she had crossed the limits of judicial impartiality. So we see that judges also in practice struggle with these opposing duties that are imposed on them. For a proper understanding of Article 6, we must, of course, be aware of the subjective and the objective approach of the court, of the European Court of Human Rights. This approach gives a nuanced way of looking at Article 6 and looking at cases. And the subjective approach, it's very important to examine the actual mindset of the judge. Is the actual mindset of the judge, is that an unbiased mindset? Is it an independent mindset? Well, that approach, of course, is rather difficult because the mindset of the judge is in principle hidden in the world of the thoughts of the judge. May manifest itself in words or in gestures, but it's difficult to find a violation of Article 6 from this subjective approach. The objective approach is also there, which makes it a little bit more easy to conclude to violations of Article 6. And in this approach, it is examined whether, apart from the exact behavior, words, speech of the judge in the case, whether they're taken as a total, the situation as a whole, whether that situation gives rise to doubts about the judge's independence or impartiality. And the perspective that is assumed is a perspective of what is called by the European Court of the external or objective observer. So he looks from the outside to the judge, and is an objectified doubt present about the judge's impartiality. The case law of the European Court of Human Rights shows a few violations from the subjective point of view. For instance, the case Levens versus Latvia, about a judge who was very outspoken during the trial in the media, in a newspaper, about her opinion on the case. Well, she said, well, I'm not sure what I will decide in the case, whether this suspect is guilty or, well, only partly guilty. Well, that is obviously a violation of Article 6. Which is also important to understand is that from the objectified point of view, appearances are very important. It's the external observer looking at the situation, and he looks at the outside appearances of the situation. And this may lead to far-reaching situations which appearances prevail over the facts of the case. An interesting example is the case Pascal versus Ukraine. Pascal versus Ukraine is a case from 2011. And here it was complained by parties in proceedings that the judge had given an interview in a Russian newspaper, and where she had expressed herself in a highly biased way. And it was right, it was true, the text of the interview was very biased. But the thing was, the judge denied ever having given the interview. So, starting from the point of view of the judge, that she hadn't done anything wrong, appearances prevailed in this case because the European Court concluded that there was a violation of Article 6. That was because the Ukrainian authorities who examined the case, who investigated what had happened, could not clarify what had happened. Clarify how it was possible that an interview was published in a Russian newspaper. Well, the judge denied having given the interview, and because it was not clarified, the appearances continued to exist. So here we have a judge who says, I haven't done anything but a violation of Article 6. Something else which is very important to keep in mind when looking at Article 6 and the exact limitations they provide for the freedom of expression of judges, is something which has been mentioned by previous speakers, and that is that there of course must be an actual effect on the case. The speech, the words, the opinion must actually be related to the case. For instance, the question which was asked a few minutes ago about recusal of judges, challenge of judges only because of their expertise. No, that from the point of view of Article, I don't think that would be able to produce a violation. There must be a specific opinion of the judge that is sufficiently related to one of the parties and often also the subject of the case. And when we look at the case law of European Court of Human Rights, most cases which I have seen about judges who express themselves in various ways do not lead to a violation of Article 6, simply because of a lack of this connection between the opinion that is expressed and the case. For instance, a judge may express an opinion through, for instance, the membership of a political party, one could say, or through an expression of an opinion could also be that judges are also members of national parliaments and are active there. But that simple activity, that single fact is insufficient for a violation of Article 6, because there must be a link to the case. So the case must also be for instance, related to the activities the judge has undertaken in national parliament. We can also see that, for instance, when we look at cases concerning the membership of the Freemasonry. There are a number of cases about judges who are members of the Freemasonry. And it's insufficient that one of the parties in the case or a witness in the case is also a member of the Freemasonry. That simple line through the case, that simple connection is insufficient. Could, of course, be different if the subject is concerned Freemasonry, because then there is this additional connection within the case, which may be problematic. So in general, Article 6 does not in general limit freedom of expression or association of judges, but only in specific situations which are relevant in those specific cases. When we look at judges who talk about cases or express opinions about their own pending cases, one could say that in those situations, the connection is given. There's a strong connection between the opinion and the case. After all, the judge is talking about the case in public. It is standard in the European Court of Human Rights that the court says the judge is required to exercise maximum discretion with regard to his cases when he is talking about his cases. Nevertheless, even then, even when talking about cases in the media, there must be a sufficient impact on the case. The opinion expressed must sufficiently impact the judge's independence and impartiality. And there are a number of examples in the case law, the case Buscemi, case Olujits, which lead to a violation. But there are also cases where judges speak in the media about the case, about the pending case during the trial, but where no violation is present, simply because the remarks are too general or quite innocent. And there is this abstract link, but not insufficient to jeopardize the judge's impartiality. An interesting question, which becomes more and more interesting also with the rise of the social media, is the question whether speech by others than the judge may affect the judge's independence and impartiality. We can see that, for instance, in the case I've just mentioned, Pascal versus Ukraine, about the judge who had an interview in the newspaper, but who denied ever having given the interview. If we follow the line of thought of the judge, there was no interview, then it's a newspaper or a journalist who has somehow made statements and then, through the construction of the appearances, affects judicial impartiality. In social media, a recent example of a situation with regard to social media is the Trump case, the civil fraud case of Trump in the United States. And Trump accused, he took the position that the judge was biased because the judge's wife had posted messages on social media about Trump, about him. And he says, well, these are really negative messages, and now the judge's impartiality is damaged. Well, in that situation, it was clarified quickly that the judge's wife did not have any had not placed any messages on the social media. But here we see how a speech by others may be relevant for the decision of whether Article 6 has been violated. It does make, however, the judge up to a point an easy target. When we look at, again, the case Pascal versus Ukraine, the judge who denies ever having given, if that is the case, the judge didn't do anything and becomes an easy target for people who are opposed to this specific judge. Speech by others can also affect a judge when the judge is part of a part of a larger chamber of judges who decides the case. There is case law of the European Court, for instance, the case OTG Mondagron versus Spain, a case which is also mentioned in the booklet, in the thematic booklet, which is part of this seminar. And that in that case, it was clear that one of the judges of the chamber of judges was partial. That had become clear through other proceedings. And the thing was, his lack of impartiality affected, or perhaps one would say, infected the entire judges. And why? Because there were deliberations behind closed doors. So from the perspective of the external or objective observer, it was completely unclear what happened behind those closed doors. So here, in view of the secrecy of the deliberations, it was impossible to ascertain what the influence was of this specific judge on the rest of the judges. And therefore, the impartiality of the entire chamber could be open to genuine doubt. In another case concerning also a wife of a judge who was active on Facebook, the European Court distinguished two interrelated questions which need to be answered when looking at the question whether speech by others may affect the judge's independence and impartiality. In this case, it was the case Rustavi 2 Broadcasting Company versus Georgia. In that case, the judge was handling a very high-profile civil case, and his wife, on her Facebook account, had posted messages sort of related to the case. They were related, well, sort of indirectly to the case, but the question came up, and it was claimed in the proceedings that the judge was no longer unbiased, no longer impartial because of the activities of the wife on Facebook. And the European Court says, first, we have to determine what the character of the statements of the posts on Facebook is. And are they of such a content that they are questionable from the perspective of judicial independence or impartiality? So first, make an assessment of the message. And then comes the second question: can this opinion of this third person rub off sufficiently on the judge, creating an impression that perhaps this is also the opinion of the judge? And if that is the case, if these questions both are answered in the affirmative, then there may be a violation of Article 6. In this case, Rustavi 2 Broadcasting Company, there's also a highly interesting dissenting opinion, and the difference of opinion between the majority and dissenter is really a difference of opinion about what the objective observer, the outside observer, the external observer thinks when he looks at the case. So the highly interesting cases, and I have the idea that judges' vulnerability grows with these social media postings, because the closer the relationship is with the person who posts these media, these messages, the more rub-off effect there may be. So these days, these media are not always easy for the position of the judge.
Sietske, sorry to interrupt you, but I have to ask you to get to the conclusion.
Yes,
so
well, I'm a final statement I wanted to make, and that is when looking at cases both from an Article 10 European Convention point of view and from a point of view of Article 6, always remind yourself that it's very important what public confidence in the judiciary is an important underlying interest. So ask yourself the question, what does this behavior, what does this speech of the judge do with public confidence in the judiciary? That is one of my final comments.